During the speeches on Kajian Sapara Pinggal RMK 11 2016–2020, Prime Minister Mahathir proposed 2-terms limit for the tenure of Prime Minister, Chief Minister and Menteri Besar. I would have no problem if the proposal is only limited for the President, by whatever style known, of the Executive Council in any of the component unit of the States of Malaya. However, if the proposal is for the Borneo states of Sabah and Sarawak, he need to face my political argument regarding the matter, and reflect hard on himself. I will not go in depth into the advantages and disadvantages of imposing a limitation into the tenure of the Chief Minister of Sarawak. The discussion will be on the rights over Sarawak State Constitution itself. If we go more in depth way back into the year 1941, the first written constitution of Sarawak was promulgated by Raja Charles Viner Brooke, with the goal of self-government that the people of Sarawak shall be entrusted in due course with the governance of themselves. Subsequently, various constitutional reform was being undertaken under the British rule from 1946 to 1963, by consultation with the people of Sarawak. The Constitution of Sarawak has undergone various reform under the British, where they always consulted the people of Sarawak along the way through many inquiry and commission. British know very well, and learn from the legacy of the former Rajas of Sarawak, that the Constitution is for the people, and the decision on how the Constitution should be constructed must be decided by the people of Sarawak themselves. Before the formation of Malaysia, on the 10th of March 1963, the Council Negeri of Sarawak has unanimously adopted the constitutional reforms previously published in September 1961. Whereby the Sarawak Constitution was amended so as to provide for a Supreme Council, Cabinet, headed by a Chief Minister, and a Council Negeri, Legislative Assembly, with a majority elected members. These changes came into effect with the dissolution of the existing Council Negeri on 1 June 1963, and for the subsequent general elections afterwards. On the 22nd of July 1963, Sarawak has a system of ministerial government and an almost completely representative legislature before the creation of Malaysia. Based on Article 3 of the Malaysia Agreement 1963, the Government of the United Kingdom will submit to Her Britannic Majesty before Malaysia Day orders in Council for the purpose of giving the force of law to the Constitutions of Sabah, Sarawak and Singapore as States of Malaysia, which are set out in Annexes B, C and D to this agreement. In accordance with Article 3 of the Malaysia Agreement 1963, on 29 August 1963, before the formation of Malaysia, the State Constitution of Sarawak was given the force of law through the Sabah, Sarawak and Singapore State Constitutions, Order in Council 1963 at the Court of Balmoral in the presence of the Queen Most Excellent Majesty in Council. This means, the State Constitution of Sarawak that was previously entrusted by the Raja Charles Viner Brooke to the British was finally given back to the people of Sarawak by adhering to Article 3 of Malaysia Agreement 1963. Not by the Federal Government of Malaysia, and definitely not by the Federal Government of the Federation of Malaya. Sarawak Constitution was entrusted to the British for the people of Sarawak through a long course of history since the first promulgated written Constitution of Sarawak by Raja Charles Viner Brooke in 1941. The intention is for the goal of self-government that the people of Sarawak shall be entrusted in due course with the governance of themselves. This must be clear. So, who is Prime Minister Mahathir, acting on behalf of the Federation of Malaya now masquerading as Malaysia, to dictate how the Constitution of Sarawak should be changed and reformed, for example, limiting the tenure of the Chief Minister to 2 terms? Sarawak State Constitution is not up for the fancy of federal government to change as they please. It must be reminded that Sarawak State Constitution has existed since 1941, and has evolved way before the formation of Malaysia. It was further formalized and given the force of law by the British for the people of Sarawak through the Sabah, Sarawak and Singapore State Constitutions, Order in Council 1963. Federal government are not the one who give the force of law for the State Constitution of Sarawak. Sarawak State Constitution is owned by Sarawak, not the federal government. Therefore, federal government has no grounds or whatsoever to change or reform the State Constitution of Sarawak. Only the people of Sarawak has the power over our own constitution. Only Sarawak has the power to decide on how the Constitution will govern our life. Not a single person in the States of Malaya can tell Sarawak on how to change or reform Sarawak State Constitution. So, Prime Minister Mahathir, don't you dare touch our state constitution. It is ours, down to the single blood of letters. For the people of Sarawak, we all know that the federal constitution has been amended and repealed for more than 600 times, regardless of the rights and safeguards of Sarawak during the past decades. So, are you going to give these people their hand to fancily change and reform our constitution now? What's next after they grab our constitution? I guess another 600 times of amendment will be done to our constitution, decided by outsider. So, Prime Minister Mahathir, Sarawak State Constitution was not created and given the force of law by the federal government. It was entrusted by our sovereign ruler, Raja Charles Viner Brooke, to the British. The British assumed the trust and give the constitution back to Sarawak. Therefore, only the people of Sarawak will decide on how the state constitution of Sarawak will be evolved for the years to come. If limiting the tenure of Chief Minister required the amendment of Sarawak State Constitution, know well that our constitution is none of your business. It is for the people of Sarawak to decide, not yours.